Hello, everyone. My name is Candice Gomez. I am a member here at Schoeneck King, and I'm also co-chair of our law firm School Law Practice Group. I am honored to be joined today by my great colleague, Lauren Schnitzer, and we are very excited to welcome you to the first installment of Schoeneck King's Private Schools Lunchtime Law Series. Bond has one of the largest school law practices in New York State, and we represent private schools throughout the state. Wherever you are located, you can find a Bond school attorney who can help to meet your needs. And we are very pleased to kick off this series. There are tons of great speakers that will be part of this series over the course of the next few months. So please check out the schedule and attend when you can. Today's topic is child abuse in an educational setting. Now, all of us on this call, I'm sure, are familiar with the mandated reporter requirements regarding child abuse when that abuse is occurring due to the actions of a parent or someone outside of the school environment. This topic tends to be a little bit more difficult for our schools because the person that you may need to report may be a colleague. It may be the person that you're going to lunch with. It may be someone that you've worked with for the past 20 years, and they may be the person who was acting inappropriately. Based on what we're going to explain to you today, there are certain requirements as to how you need to go about reporting behavior when it does appear to be inappropriate and when it does need to be investigated. So while this topic is a little bit more sensitive for that reason, because it requires us to perhaps need to report someone that we already have a relationship with and that we've worked with for many years, of course, the paramount concern for all of us is making sure that children are safe. So with that in mind, I'm going to turn it over to Lauren, and she's going to begin walking us through this topic.
Thank you so much. So today we're going to be having an overview of this topic of child abuse in an educational setting, which Candice explained is a different set of requirements than the requirements for reporting child abuse that appears to be going on at home. So this is not a requirement procedure regarding a parent potentially abusing a child at home or in the home environment. This is solely regarding our staff and our volunteers at our schools. So we're going to be going over the legal responsibilities of our school staff, who is a mandated reporter for purposes of child abuse in an educational setting, and what are all of the relevant persons required to do. Next slide, please. So what is child abuse in an educational setting? This phrase comes from the New York education law, particularly Article 23B. And there's also regulations of the Commissioner of Education that further set forth our requirements with respect to this topic. So what we're going to do now is define all of these words. What is child abuse? What is an educational setting? And what schools and children are subject to this regulation? So we're going to go through that one by one. The first and most important is what is child abuse? There are 5 enumerated examples in the law of what is child abuse. For example, if a teacher accidentally knocks into a student walking in the hallway, that is not child abuse. That was an accident. So the first example of what is child abuse that makes us subject to these reporting requirements is something that is committed against a child by an employee or a volunteer in the educational setting. For our purposes, it would be in a school or in a bus and other settings that we'll talk about later. One example is intentionally or recklessly inflicting physical injury, serious physical injury, or death. So intentionally is I'm doing it on purpose. Recklessly typically means I have no regard to the safety of those around me, and I really shouldn't have been doing this thing, like setting a fire to a room, for example, or putting a Bunsen burner on, walking away in a classroom when there's students around and you know it's about to explode. something that's reckless, something that it's pretty obvious something bad is about to happen. We should have known better. Intentionally or recklessly engaging in conduct that creates a substantial risk of physical injury, serious physical injury, or death. Again, something that there's a substantial risk, something bad is going to happen to the child. Child sexual abuse, that's defined in the New York State Penal Law, Articles 130 and 263. And the commission or attempted commission against a child of the crime of disseminating indecent materials to minors, also defined in the penal law. If there's ever a question regarding whether a suspected act by an employee or volunteer involves sexual child abuse or the crime of disseminating indecent materials to a minor, certainly reach out to counsel and work out figuring out whether or not that potential conduct is covered by the statute. Next slide, please. Most recently, in 2023, the law was amended to add another act that encompasses child abuse in the educational setting, and that is the use of corporal punishment. And corporal punishment is a defined term by the Commissioner of Education. As an overall mandate, school staff, all school staff, public and private schools, are prohibited from using corporal punishment. What is corporal punishment? This is any act of physical force upon a student to punish the student. It does not include using physical restraints to protect the student, staff, or others from physical injury. When alternative procedures, alternative methods that don't involve physical restraint can't reasonably be employed to achieve the purpose of protecting the people around the child. If we have to put a child in a proper hold because of a safety issue, that's an appropriate action that is not corporal punishment. If a teacher walks by a student who's not paying attention and they hit the student on the face and say, hey, pay attention, you're being bad, and that's a punishment, that's corporal punishment. Again, that's just an example. If there's ever a potential allegation of corporal punishment, again, reach out to counsel and we'll try to figure out if it fits within this definition of corporal punishment, which is something that's required to be reported as child abuse in an educational setting pursuant to these rules. Next slide, please. So what is an educational setting? What are we talking about? What location are we looking at? Certainly our buildings and grounds of the school itself, certainly school vehicles, extracurricular activity sites. If we have a class trip, if we have a trip of a sports event, anything that's arranged by or organized by the school or a school event, extracurricular event, that's all going to be covered. If something is happening during one of those events or on a bus, that's something that we may need to report under this statute. Any other location where direct contact between an employee or volunteer and a child has allegedly occurred. What does that mean? If they're off premises and there's an allegation that the employee or volunteer is engaging in one of those examples of child abuse that we reviewed, that's something that we have to report. If there's an allegation that the student and the employee or volunteer are at an offsite location, we're going to look at it, we're going to think about it, and we're going to say, is this something we have to report? And we're going to go through this process. They don't have to be in school for this to be covered by the law. Next slide, please. When we're talking about child abuse in the educational setting, the word child is in that phrase. This is anyone under the age of 21 enrolled in the school. When in doubt, report. Doesn't hurt. Next slide, please. And what schools are we talking about? Who's covered by the statute? Non-public schools are covered. Charter schools, our public school districts, our public schools, BOCES in New York State, and all New York State approved preschool special education program, and the etc. on this list. There are some other schools that are approved by New York State that are also covered by the statute. Next slide, please. Mandated reporters. Within the law regarding child abuse in the educational setting, there is a very long list of individuals who are required to report. These individuals, if they're ever made aware of a potential incident or incidents of child abuse in the educational setting, these individuals should be reporting, required to report pursuant to the law. The requirement for reporting is within one school day. We must report our allegations of child abuse in the educational setting. We'll talk about this further in a few slides, but if you hear about something in the morning, report it before you leave for the day. If you hear about it at the end of the school day, make your best efforts to make the report before you leave. And if you can't, do it the next morning, or even do it off premises if you can. We want to make sure we report immediately within one school day. Again, if not the same day, the following morning. And here we have the list of our mandated reporters. This is the beginning of the list. As I said, it is a quite lengthy list. All school administrators for our private schools, that would include our heads of school and other school administrators, our teachers, nurses, guidance counselors, psychologists, social workers, our board members. Next slide, please. Anyone else working in our school who is required to hold a teaching license or certificate or an administrative license or certificate, our school bus drivers, or anyone else who is employed to provide transportation services for our schools, physical therapists, occupational therapists, speech and language pathologists, teacher aides, and our school resource officers, if we have those. Next slide, please. That is a very long list. It is a very detailed list. The rule of thumb that we recommend is anyone who is made aware of a potential incident of child abuse in the educational setting are strongly encouraged to report. What does that mean? If I'm not on the list, or I'm not really sure if I'm on the list, but I know something might be going on, or a child said something to me, a parent said something to me, or maybe I saw something that I thought might be covered, I may as well report. That is our best case scenario for the individual and also for the school itself, to make sure that your children are protected, that anything that might be happening, we find out about and we're able to look into it. Next slide, please. Speaking of what should I do, the state regulations do have a requirement for training. Every school, and this includes our private schools and our non-public schools, must implement on an ongoing basis a training program regarding these procedures for reporting child abuse in the educational setting. This is in place for all our current staffers, but also any new hires who come in who are covered under a section of the mandated reporters. If we have a new staff member who's a mandated reporter and they come in, let's say in December, and your training was in September, let's make sure those new mandated reporters are trained, even if they come in in the middle of the school year. We also have to provide, on an annual basis, our teachers and our school officials with a written explanation concerning this reporting process. And of course, the easiest way to comply with that rule is to provide it to all of our staff members. If everyone's getting training, the best course of action would be to give everyone that written document. But at a minimum, the teachers and school officials are required to receive that written explanation regarding these reporting requirements. For schools that are not school districts or public schools, our teachers, administrators, and school bus drivers are also required to complete 2 hours of coursework or training regarding identifying and reporting child abuse in the educational setting, but also child abuse and maltreatment more broadly. And this would include child abuse in the home setting as well, and not just in the educational setting. So that is a different requirement. It has our 2 hours of training for this entire topic of child abuse, not just child abuse in the educational setting. That's covered by our first 2 points with respect to training. Next slide, please. So what are our reporting requirements? What are we supposed to do? If there is an allegation of child abuse that comes in, and it's regarding a child who attends the school where the mandated reporter is employed. So for example, a teacher of the school finds out that there's an allegation regarding child abuse for one of the students in that person's school. What should they do? This mandated reporter, once they learn of this allegation, should promptly, again, within one school day, preferably same day, if not the next morning, should complete a written report of the allegation on the report form that's required by the Commissioner of Education. This report form is readily available on the State Education Department's website. It's a very short form. It's pretty easy to fill out, has a couple of sections, and if they have any questions, they can certainly speak to an administrator when completing that form. Once your mandated reporter completes the report form, again from the Education Department, they are to personally deliver that report form to their building administrator or principal. And then we should also be sending it to the superintendent or the school administrator. For non-public schools, the responsibilities that are outlined in the law for superintendents equally apply to our non-public school administrators. So throughout the presentation, we'll talk about school administrators and heads of school. Those are the same rules that apply to our public school superintendents. If there's an allegation that involves a child who was allegedly abused by an employee or volunteer at a school that is not where our mandated reporter works, for example, the mandated reporter finds out of a potential child abuse in the educational setting regarding a child who attends a different school, either a public school, a BOCES, a different school, not our school. What are we supposed to do? Our mandated reporter must, again, promptly, within one school day, complete the report form, which is available on the Department of Education's website, and then deliver that report form to the superintendent of schools or school administrator for the school where that child attends. And they are to provide it to the superintendent of schools or school administrator for the school in which the abuse allegedly occurred, if that is different. This could happen on an extracurricular activity or a field trip if there is an allegation that a child from a different school came onto one school property, there was an incident with the staff member or volunteer, and then that child went back to their home school. So now we have two different schools involved. We have one school where the child attends. We have another school potentially where the abuse allegedly occurred. We're going to make sure we advise both schools of this event and both schools receive the report form. What are the obligations of our building administrators, our principals? What are they required to do? They are the ones who receive that completed report form. If it wasn't sent to the superintendent, your school administrator, your head of school, your principal or building administrator must immediately provide that report form to their school administrator, their head of school. Make sure they have a copy as well. Our building administrator should promptly consult with that school administrator or a head of school to talk about this allegation. Because they have the obligation, as further set forth on this slide, to determine, is there reasonable suspicion to believe that child abuse actually occurred? Right now, we only have an allegation that's written on the report form. It is very important, as noted in the third bullet point, our building administrator, our school administrator, they are not permitted to share a copy of this report form of the mandated reporter's allegation to anyone else at the school. They are to keep it to themselves and talk amongst themselves and make a plan to make this determination of, is there a reasonable suspicion to believe that an act of child abuse has occurred? Sometimes it happens that the allegation was brought to the attention of the mandated reporter by someone other than the actual child involved or their parent. In those cases, if it wasn't the child and it wasn't the child's parent or guardian who made the allegation, our building administrator is required to find out from the reporting person the source and the basis for their allegation and make sure that's on the report form as well. When we're making the determination of whether or not there is this reasonable suspicion to believe that an act of child abuse in the educational setting has occurred, we have to look towards that definition that we reviewed in the first couple of slides. Was this an accident, or was this something that was intentional or reckless? Did it involve physical injury, serious physical injury or death? Did it involve a substantial risk of physical injury, serious physical injury or death? And again, was it intentional or reckless on the part of the person committing the act? We are to look at the child sexual abuse, if need be, our definition of corporal punishment, again, if necessary, and regarding dissemination of indecent materials, we're going to look at if those allegations are involved, if there is a reasonable suspicion to believe that that actually has occurred. This is going to be a very fact-specific determination. The building administrator, the head of school, whomever is making this decision, or if they're making it together, they are to look at all relevant data that's available to them. If there's a surveillance video that shows the alleged incident, they should take a look at the video, interview people that are involved, review any documents that are produced. Talk to any relevant individual of whether or not there was an incidence of child abuse in the educational setting. Next slide, please. It is possible that following this investigation, this determination of whether or not there is a reasonable suspicion comes out to be positive. So what does our principal building administrator do if he makes the determination that there is a reasonable suspicion to believe that an act of child abuse has occurred? If the building administrator makes this determination, the building administrator must promptly notify the parent that an allegation of child abuse in an educational setting has been made. They are to promptly provide the parent with a written statement setting forth the parental rights, responsibilities, and procedures, and prepare that writing in accordance with the commissioner's regulations. The commissioner's regulations provides the exact language that we are to provide to parents if there is an allegation of child abuse in the educational setting following this reasonable suspicion determination. As attorneys, we draft these a lot, so certainly reach out to counsel to make sure you have that correct written letter and that it includes all the information within the regulations that are required to be sent to the parent. In addition, there is a requirement for the building administrator to promptly provide a copy of that initial report form that we spoke about a few slides ago and send it to the appropriate law enforcement authorities. Next slide, please. If we're in a situation where a report form is forwarded to law enforcement because there was a finding of reasonable suspicion that an act of child abuse has occurred, our school administrator or head of school, they are required by the regulations and the education law to send the report to the commissioner of education. This is only involving individuals who are the subject of the allegation, our volunteer or our employee, if they hold a certificate or a license issued by the New York State Education Department. The classic example for one of these individuals would be a New York State certified teacher. So if a New York State certified teacher an individual who holds a certificate issued by the New York State Education Department to teach in our New York State schools, if that individual is the subject of a finding of reasonable suspicion that an act of child abuse has occurred, then our school administrator or head of school must make sure that they forward that report form to law enforcement.
Great. Thank you, Lauren. So now we will talk about instances in which there is no reasonable suspicion, because of course, not every allegation is ultimately going to be founded. Some of them may actually be substantiated, and the building principal may determine that there is reasonable suspicion, and Lauren has just laid out for us the steps to follow if there is reasonable suspicion for that building principal to believe that child abuse in an educational setting occurred. But in an instance in which the allegation is not founded and the principal determines that there is no reasonable suspicion to believe that an act of child abuse has occurred, then that principal should use his or her discretion regarding how to notify the parents that an allegation was even made. Of course, if the child or the parent brought the allegation to you, you should absolutely make sure that you follow up with them because they will be waiting to hear about what has happened as a result of their allegation. It is our recommendation that the building principal call the family and have a conversation and then follow up in writing regarding the steps that they took to look into the allegation and how they reached the conclusion that there was not reasonable suspicion. Although a phone call is not mandated by the law, and even putting it in writing is not mandated by the law, in a circumstance like this, it's best to cover yourself and to make sure that you have some type of documentation regarding the fact that you did conduct an investigation. So that's why the written email or letter to the parent is important. And then from just a personal standpoint, the phone call is important because, of course, we're dealing with people's children, and having that personal touch and that personal reach out to say, I know this is upsetting to you, mom or dad, but I just wanted to explain to you what has been happening here, really goes a long way in terms of making sure that parents feel well informed and able to properly address the situation. What is an example of a time when there is no reasonable suspicion? One example that comes to mind is an instance that we had in one of our schools where the students were lining up in front of the building in order to get onto the bus. It was dismissal time. The parking lot was busy. There were parents coming and going, buses picking up, and a student who was quite young and didn't quite have control over their bodies enough and kind of the mental wherewithal to know that this was a potentially dangerous situation, tried to dart out into the parking lot. And the teacher who was standing close to that student just grabbed the first part of the student that she could, which happened to be a hood, and grabbed the back of the hood and kind of pulled the student back so that he was not able to run out into the parking lot. Of course, if you kind of did not know the circumstance, or maybe you were looking at this from afar, you may think that this teacher did something intentionally to hurt the student once you see the student kind of abruptly almost flying backwards. But of course, upon investigation and looking at the video and speaking to the other people who were there, it was very clear that the teacher did that with no intent to harm the student. In fact, it was the exact opposite, to make sure that the student was not injured. So that is an example of a time where there may be physical contact that looks inappropriate, but there's no reasonable suspicion to believe that an act of child abuse in an educational setting had occurred. Next slide, please. Confidentiality. This is very important. All reports, records, photographs, and other material must remain confidential and may not be disclosed except to law enforcement in the event that reasonable suspicion is found, or as otherwise authorized by the law. For example, the principal is able to send a copy to the superintendent or to the head of school. The superintendent or head of school is then required to send it to law enforcement if there is a founded allegation, as well as sending it to the Commissioner of Education. But these are not documents that should be kind of circulated and becoming part of the school rumor mill. We know that sometimes when an allegation is made, especially if it involves a staff member, it could spread like wildfire. And the intent of this part of the statute is to make sure that when allegations are made, people do not rush to judgment, and rumors are not circulating that ultimately may be found to be not true. The willful disclosure of the materials we've been talking about, the reports, the photographs, other materials, to a person who was not authorized to receive it, could be a Class A misdemeanor. So it's beyond just a slap on the wrist. You really did something that you shouldn't have. There could be actual legal criminal consequences here as a Class A misdemeanor. Building principals and heads of school need to exercise reasonable care to prevent unauthorized disclosure. This is not a report that you should leave on your desk if you have people coming and going in and out of your office. This is not a report that you should have kind of in a common data drive that anybody is able to access on the computer system and easily take a look at. We've got to almost treat this as though it's in a separate locked file cabinet, whether that's in a physical file cabinet or an electronic file cabinet, so that unauthorized disclosure does not occur. Next slide, please. Penalties for failing to report. There are instances in which a person may not want to report. Maybe they are not sure about whether or not the allegation is true, and they decide that they just kind of want to see how things play out, and they're not going to make the report. That's exactly the wrong thing to do, and exactly what we advise administrators and staff not to do. We understand that sometimes what we see may be troubling, and we don't want to accuse any of our colleagues without knowing for sure whether or not our instincts are correct. But that is the point of an investigation. It's not our job on the front end to be judge, jury, and executioner and to decide whether or not this is child abuse in an educational setting. It's only our obligation to submit the report so that someone else can look into it. And after looking at all of the various factors, that other person, the building principal, the superintendent of schools, will make the decision as to whether or not the allegation is actually founded. But if we hold back because we're not sure about whether our eyes actually saw what they saw or whether our ears actually heard what they heard, that could be a willful failure on our part. And that, of course, can make us susceptible to either penalties from the Commissioner of Education of up to $5,000 or civil litigation, because in the event that this was actually child abuse in an educational setting and we failed as mandated reporters to report it, that parent may come forward later on and assert an action against us that could result in personal liability. Or it could be a student who is over the age of 18, but under the age of 21, who is still subject to this law, who makes a complaint against us in the form of a lawsuit. Yes, there are monetary penalties. Yes, there's civil litigation involved, but at the end of the day, the most important thing for us to remember is we do not want a child to potentially continue to be the victim of abuse because we failed to report it for a reason that was not justified. When in doubt, report. Someone else will look into it and figure out whether or not it's actually founded. Next slide, please. No quiet resignations or voluntary suspensions. This kind of dovetails with what we were talking about before, because what was happening in years past, and we hope that it's not happening anymore, are situations in which people don't want to ruffle feathers. They don't want to go through lengthy and timely investigations. So we had situations in which a principal or a head of school will say, listen, teacher, we don't know what happened here, but we don't want to go through all of the motions with you. So if you just go ahead and submit your letter of resignation, put it on my desk by 5 p.m. today, we'll accept it and you can go off into the night, and this won't be a problem for us. It won't be a problem for you. We'll just part ways here. Yes, it may have been more convenient for the school in that moment in time, but what did it result in? It resulted in bad apples being passed from school to school because someone would resign. There was never an investigation. There was never any type of oversight from the Commissioner of Education or law enforcement, and these people were being allowed to go from school to school, engaging in abuse against children without ever being properly reported or investigating. We cannot allow that to happen. There are no quiet resignations, so there are no situations in which we can say, if you resigned, we won't investigate. There are no suspensions in which we can impose that will substitute for what law enforcement does. Violations of this prohibition can result in a Class E felony charge and a civil penalty of up to $20,000. And again, there's also the potential for civil litigation, meaning personal liability. Next slide. immunity from civil liability. This comes up a lot with our staff members because it's very understandable that they ask, well, what happens if I'm wrong? What happens if I make this allegation? It turns out not to be true. Won't this other person, the staff member that I reported, then come forward and say, you engaged in slander or defamation against me, and now I'm going to sue you because you hindered my ability to get a promotion, or now everyone in the building thinks that I am a child abuser and nothing came of it. First of all, not everyone in the building should know about it because we talked about the confidentiality rules before, but also it's important for us to know that the law provides immunity from civil liability for employees, volunteers, principals, and heads of school who reasonably and in good faith make a report of child abuse in an educational setting. Reasonably and in good faith. What does that mean? That basically means anytime you make a report, as long as it's not done maliciously to purposely harm someone's reputation or to purposely make an allegation that you know is untrue, you're going to be covered. You're going to have immunity from that civil liability. The only circumstance in which you kind of fall outside of that box of safety is when you go out of your way to make an allegation that you know to be false. Next slide, please. Record retention for unfounded reports. What happens with a report in the event that reasonable suspicion is not found and the person is not someone who engaged in child abuse in an educational setting? It can be held for this by the school for up to 5 years from the time that the report was made. And this time period, we always ask our clients to consult with us about because in light of developments that have occurred along the way, including the Child Victims Act, there may be circumstances in which it could be beneficial to a school to hold on to these reports longer than the 5 year period. If, for example, someone comes forward 20 years from now and says, Mr. Smith abused me and the school never looked into it, we may want to have some way of documenting the fact that there was an investigation. We did all of the proper procedures, and ultimately Mr. Smith was found not to have engaged in that. This was not an act of neglect by the school. Rather, it was the result of a proper investigation. So before you throw out those reports, please make sure to consult with your school attorney. Next slide, please. We're going to talk through a fact pattern in the last couple of minutes that we have together. And the facts may seem a little bit outrageous, but as you'll find, I'll kind of give you the spoiler up front. This is a real case. This is not something that we made up. And as bizarre as it may seem, these are the types of situations that actually occur in real life. And it really illustrates the point that one person may have one piece of the puzzle, but you don't have the entire puzzle. So that's why if you see something that looks or sounds inappropriate, report it. Because upon receiving that report, there may be other elements, there may be other puzzle pieces that come out and actually make a much bigger picture and a much more disturbing picture than you could have actually imagined up front. And that picture would not have been discovered but for the fact that you made a report and a proper investigation was conducted. So in this case, we have a student that reported to her friend, another 16-year-old high school student. So we have two 16-year-old female high school students who are friends. And one friend tells the other friend that she was spending private time with the male teacher at the school. That male teacher had gone to the female student's dance class in the evenings, and he was talking with her privately at that location. I'm going to pause there because I want to highlight something that Lauren talked about before in terms of what is an educational setting. We're not talking here about something that happened in the classroom or on school campus. This happened at the dance class. Was it an educational setting? Absolutely, because you're never off the clock and you're never out of range when it comes to child abuse in an educational setting because it can occur anywhere that contact between a staff member and a student occurs. Doesn't matter where it is. If that contact is happening and it's inappropriate, that falls under the umbrella of child abuse in an educational setting. To go on with the fact pattern, the student said that the teacher had given her friends gifts and driven her in the car. And the student also said that this friend had many phone conversations with the teacher. So one friend is coming forward to a school employee and basically saying, let's use a random name here. Amy told me that this male teacher is coming to her dance class, giving her gifts, driving her around in the car, having phone conversations, and it seems a little strange to me. This is what this friend is telling the teacher. Next slide, please. Of course, the real case here is Matter of Binghamton City School District. It's a 2006 case. It involved a 32-year-old tenured teacher and a 16-year-old female student. There was almost constant phone contact between these two individuals. The student frequently visited the teacher in his office at school, even though he was not one of her teachers. That may seem ordinary in some cases, but these are the types of clues we should watch out for. If a student is visiting a teacher in his office after school, teacher is not currently assigned to that student, and this contact is happening more than you believe to be appropriate, and at times that seems strange, this doesn't necessarily indicate child abuse, but it should be something that gives you pause and you think about. The teacher called the student 1,329 times within a 6-month period, including while he was on vacation. Next slide, please. The teacher once called the student 21 times in a single day. Remember, this is a 16-year-old student getting called 21 times by a teacher in her school in one day. The teacher was giving the student phone cards in an effort to try to have the student call him without these calls appearing on certain phone bills, was going to the student's dance class in the evenings, driving the student around in his car. And at some point, this gets the attention of someone in the school, and the student's mother, the 16-year-old female who's being impacted, and 3 school administrators tell the teacher to stay away from the student. Basically, the school administrators say, we don't know exactly what's going on here. We're hearing a lot of buzz, chatter about things happening, and we don't know what's happening. You're telling us, teacher, nothing is happening. We just want you to stay away from this student. And mother is also saying, just stay away from my daughter. I can't prove anything, but I just want you to stay away from her. Next slide, please. Despite being told to stay away, the teacher drives the student to his home when his wife was out of town, closes the blinds, and spends 6 hours alone with the student in his home. Mom finds out, she goes to the teacher's house, she's pounding on the door until his daughter comes out of the house, and the daughter says that the teacher loved her and was leaving his wife to be with her. Next slide, please. The student and teacher denied any sexual contact, and of course, the school district rightfully brought this teacher to a hearing. The hearing officer suspended the teacher for 1 year without pay, which of course had the school district rightfully enraged because they're thinking, how much more blatant than can it get? We went through the facts here, and I think all of us are pretty shocked at what happened here. Ultimately, it was appealed by the school, and the New York Supreme Court and Appellate Division ruled that the penalty to the teacher, that 1 year suspension without pay, was not harsh enough. The court found that the penalty was shockingly lenient, and they vacated the hearing officer's decision so that a new penalty could be imposed, and they found that the hearing officer's decision failed to protect the public. Next slide, please. The appellate division found that New York's explicit and compelling public policy to protect students from harmful conduct of adults, particularly in an educational setting, needed to be taken much more seriously. And when an educator's conduct involves inappropriate contact with students who are minors, this policy gives the highest priority to protecting their welfare. So in other words, it is more important to keep the children safe than to keep this person's job safe. Next slide, please. So we went through that case just to kind of give you a real life example of some of the strange but true situations and why it's so important for us to notice what's happening in our surroundings, to report when necessary, and to make sure that we're taking our mandatory obligations very seriously. I see that we are at the end of our time today. We're so pleased that you could join us. Please try to join us for the next installment of this webinar series. We will have 2 other great attorneys speaking to you at that time. And on behalf of both Lauren and myself, thank you all and have a wonderful day.
Thank you, everyone.